all over the Supreme Court building. If you've been there, you know this. Maybe if you've been there, you don't know this. There are tortoises etched into the stonework. You can see them right there. They are allegories for the slow and steady pace of justice. And now the Supreme Court has to decide if those tortoises will become emblematic of the way the nation's highest court allowed a former president to run out the clock or not. Joining me now is Mary McCord, former senior Justice Department official and the co-host of the essential and indispensable Prosecuting Donald Trump podcast. Mary, thank you so much for joining me. I want to paraphrase the great Dahlia Lithwick, who wrote that this ruling from the D.C. Circuit Court of Appeals is a bench slap. Do you agree with that assessment? And how does a sort of ruling in the slap category figure into the way the Supreme Court might look at this case?
Well, if by bench slapper she means it is chock full of quotes like those that you read at the top of the hour, and I could read you a dozen more if we had more time, it is really just filled with well-stated, pithy conclusions of law rejecting Donald Trump's arguments. And that's his arguments that separation of powers requires the president to have immunity for official acts. The court rejects that. It rejected his argument that policy reasons, a concern about chilling, and this is something that the former president likes to say every time he speaks, that a president can't possibly function as a president. He would be chilled from doing what he needs to do. Even he likened himself to Truman, that Truman would have been chilled in making a decision to end World War II with the atomic bomb, that he would have been too chilled to do that if he didn't have immunity. They rejected those arguments, and they rejected handily the argument that he can only be prosecuted criminally if he were first impeached and convicted by the U.S. Senate, which of course they rejected. So for each one of these arguments, it is a bench slapper. It is just filled with, very, in my opinion, persuasive legal conclusions rejecting those arguments. It's also something that, because, as you indicated at the top of the hour, it was a unanimous per curiam decision, meaning no one judge's name is on it with the other judges joining. They all agreed to everything in that decision. It is something that shows unity. And remember, this is a panel that had judges appointed by both Republican presidents and Democrat presidents. And it actually does give the Supreme Court the opportunity, if they so choose, to decide they aren't going to stay the mandate. They aren't going to accept cert. If 5 of those judges don't want to stay the mandate will not be stayed. Now, it only takes 4 to grant cert, but that's why I think this decision on whether they will grant a stay is an important one, because if they don't grant that stay, that means there's 5 there that agreed they didn't want to grant that stay. And they could, if they wanted to, they could say, we're staying out of this because this decision is right, it's unanimous, and time really is of the essence. Now, I don't know that I'm gambling on that, but it certainly is an option available to them.
Yeah, and let's just slow it down before we get to the end of the story here, because we have the great Dahlia Lithwick. I quoted her, and she arrived. Senior editor at Slate, covering the courts. Dahlia, we were saying how you called this ruling a bench slap, and the way in which Mary points out, it's just, it's a unanimous decision. It took a long time coming, but man, it's a doozy. And you point out today that, in some sense, the Supreme Court shouldn't even take this up because it's so plainly obvious what the law says. Do you think the court will take it up anyway?
That's the question. I agree completely with you and Mary. This is an easy case. There is no set of facts under which the court is going to grant this and future presidents blanket immunity from criminal prosecutions for starting insurrections or other felony. I mean, it's such a crazy notion that he could win. And the standard should be, right, that the court has to have some reasonable belief that he could prevail. And so the easy answer is, if you look at the merits, This is not hard. The court should bat it away. I think the question you're asking under the question you're asking is, can the United States Supreme Court, the imperial court that has inserted its nose into every part of our lives, whether it's what is clean water, what is clean air, President Biden's loan forgiveness, there's nothing this court doesn't want to have the last word on. And so can it stand humbly back and say, you know, we think the D.C. Circuit panel got it right, and we're going to let this go back to Judge Chutkan and go to trial? And that's a harder question. For this court to show humility at this stage of the game, it's hard to believe that's coming.
Yeah, I saw where you were going with that once you sort of refreshed everyone's memories about the degree to which this court sticks its nose in other agencies' business. Mary, you talked about the various scenarios here, and I think a lot of this, especially when we start batting around terms like cert, et cetera, it's confusing, right? So just to unpack it a little bit, there's whether they decide to take it up, and then the issue of the stay. Can you talk a little bit about the scenarios there? A stay basically means the case with Judge Chutkan remains frozen and nothing can happen, right?
That's right. So right now, that case is remaining frozen until Monday. And what the D.C. Circuit panel said is that if Donald Trump files by Monday a motion in the U.S. Supreme Court seeking a continuation of the stay of the trial court, that's Judge Chutkan's trial court calendar, pending filing a petition for cert, if they do that, then the stay would remain in place, of course, until the Supreme Court actually takes action by either accepting the case for certiorari, meaning just accepting it for its own review, or denying certiorari, meaning so it's denied, it all goes back to Judge Chutkan. So that's why so much rides on this idea of a stay. Now, I will note that back in one of the cases that you mentioned in your leadoff, Trump v. Thompson, this was the case where Mr. Trump sued to prevent the archivist from providing presidential records, White House records, to the House Select Committee to investigate January 6th. After Mr. Trump's argument was rejected in the district court, rejected by the D.C. Circuit, again in a unanimous opinion, it was Mr. Trump then sought a stay of that ruling in the Supreme Court and cert, and the court denied that stay, denied cert, and the documents that had been requested by the House Select Committee started going to them immediately. So that is a case that was also involved issues of sort of executive privilege, which is very comparable to executive immunity. And it was something that the court had never squarely decided on the same type of facts. And they were content to be, I think you used the word humble, and stand back and let that D.C. Circuit panel decision stand. Again, this is a different case, but there is precedent for this. And as much as this court has taken up cases across all the issues and more that Dahlia mentioned, I don't know that they are that anxious to get into something like this in an election year and be the ones responsible for the outcome here, which will have an effect on the presidential election.
Dahlia, I mean, what is your sort of read on this, given your wealth of knowledge about the Roberts Court and the sort of national importance and the really abbreviated timeline on which things need to happen in order for the American voters to understand whether one of the presidential nominees is a convicted felon or not?
I mean, there's one other piece to the puzzle, and that is in less than 48 hours, the court will be hearing another issue about whether he can be removed from the ballot in the state of Colorado and other states, presumably if the court were to say yes. And so this is only the first of two cases this week in which the court is being asked to intervene in the 2024 presidential election. And I actually agree completely with Mary that you are looking at a court that has, we say this so often when you and I talk, the lowest public approval ratings since Gallup started polling, a complete lack of public confidence in the integrity of the justices and their ability to adhere to ethics. We had a massive unprecedented leak in the Dobbs case that wasn't investigated. So I actually think Mary's onto something when she says, does the court really want to be the decider in case after case after case after case? Because there will be more cases. We know Donald Trump is going to appeal anything he can up to the court. So I suspect we'll hear more of these. And I kind of agree that if the court wants to look as though it is indeed above partisan politics, putting a thumb on the scale or taking a thumb off the scale for the president when the D.C. Circuit got it right, what's the point? I think it is exactly correct to say they're already in it up to their eyeballs in this Colorado case, and that's going to be a pretty hairy case for them to decide. Why take a bite at this one when Donald Trump cannot plausibly win it?
Just really quickly, Dahlia, if they don't decide to take it up, that effectively means it goes back to Chutkan and things move forward. Is that right?
Things move forward. She's already scrapped the March 4th trial date because this took a long time. But it could very, very realistically begin in the spring and be decided by the summer if the court just kicks it back and says, Judge Chutkan, on your mark, get set, go.
Wow. Okay, well, we're waiting. That's all I got to say. Dahlia Lithwick and Mary McCord, thank you both so much for your time tonight. Really appreciate it.